Your Honor, Judge Laro, it was certainly a pleasure listening to you. So much insight. You know, we all want to do the hot tubbing thing with you. You know?
Sure.
And you know, from that premise, we were talking a minute or two ago, and you mentioned there were a few other things that you would have loved to cover in a little more detail. Why don't we, at this moment, talk about some of your thoughts on the discount for lack of marketability and where that may be going?
Well, I'm very interested actually in the discount for lack of marketability from a judicial sense as well as maybe even an academic sense. It is probably the largest discount and probably the most important discount. Despite all of that, there does not appear to be one clear method for determining the lack of marketability discount. There are different valuators and different academic people that have views as to how to do it, but there's not one clear method. And yet if you put all the different methods together and you analyze them separately, it could very well be that you will come out with different conclusions depending on which method you used. It's sort of like an example, for instance, every year somebody presents hypothetical taxpayer information to a variety of tax return preparers, and only to find out that they get different answers depending on who's doing the preparing. And so I think we need to focus in on this lack of marketability discount. Moreover, everything that comes in by way of expert testimony in a federal court should go through this threshold called Daubert testing. And I don't really think that the lack of marketability discount has been Daubert tested. At some point, that's going to become an issue. I think that the reason perhaps it hasn't up till now is simply because there's sort of a custom to let it glide through. But that doesn't seem to be the future. People are looking at these things much more critically now, and lawyers will begin to critically determine whether or not the evaluators have used the proper method. So I'm very interested in this lack of marketability and how it also plays with the minority discount as well. So if there had been more time today, I guess I would have dwelt on that more.
Great. Let me just ask one last question. How do you see, what do you see as the future, and how do you see this concept of hot tubbing getting used into the future?
All right. Well, first of all, I would say that the future for the valuation industry is strong. There are 243 sections in the Internal Revenue Code that involve fair market value. Congress keeps putting more and more emphasis on valuation, not only for charitable reasons, but for all other reasons as well. And so the valuation industry, I think, is very strong. Hot tubbing is a technique that plays to the fact that it allows experts to communicate directly with the judge on a conversational basis, to inform the judge, and to do so by speaking with one's colleague conversationally, as opposed to adversarially. So I think it has a future, but I think it's slow. The American Bar Association has studied it. They've talked about it. Other courts are beginning to look at it and do it. I've done it probably, I was the first one, I believe, to do it in the United States, and I've done it 6 or 7 times, and I'm going to continue to do it. And but it'll be slow in terms of its evolution.
Great. Well, thank you, and thank you for this additional time this morning.
You're welcome.
Honor.
You're welcome.